Does a spouse have any rights regarding property located outside of Ontario in a divorce?
Rights to property located outside of Ontario. Definition of property in Ontario. It is important to outline what constitutes property upon breakdown of the marriage in the context of family law disputes in Ontario. The Family Law Act, which is the pertinent legislation in Ontario dealing with proprietary rights in the context of family law, defines property as any interest, present or future, vested or contingent in real or personal property. Such property can be located within or outside of the province of Ontario. While the Act does require the parties to include all interest in property, no matter where it's located, for the purposes of equalization, the Family Law Act does not deal with the actual physical division of any of such property. When would it be required for a court to make orders with regards to property? Our courts in Ontario are often asked to determine ownership interests in property and asked to order the sale of property. As a result of these questions being asked of the courts in Ontario, they are required to make orders with regards to property. The legal notion that Ontario courts do not have the authority to make an order as against foreign property is founded in case law. There have been numerous decisions rendered throughout our Canadian legal system which have stated that Ontario courts do not have the authority to award any order over property when it is located outside of its provincial jurisdiction. With parties accumulating more and more marital assets outside of the province, and with the case law in place stating that Ontario courts do not have the authority to award an order over property itself located outside of the jurisdiction, there has been an increasing trend amongst litigants towards attempting to seek relief from our courts through common law claims. Parties are requesting the courts make an award in personam, whereby the courts will compel a personal obligation on an individual. For example, as the courts cannot award the sale of a property located outside of its jurisdiction, as it does not have the authority to make an order against the property itself, the in personam award allows the court to obligate an individual himself or herself to carry out an action which provide for the same result as if an order was made against the property itself. There seems to be conflicting mindsets as to the court's authority to make orders with regards to foreign property. On the one hand, there is the general rule that determined by case law that Ontario courts cannot deal with property located outside of its jurisdiction. However, with the increasing amount of common law claims being put forward, the courts have demonstrated its willingness to grant such in personam relief in exceptional cases. There are no clear-cut answers with regards to the Ontario court's authority when handling issues relating to foreign property, and it is necessary to seek proper independent legal advice when any related issue associated with foreign property arises.